Hello students, good morning all. This is me, Dr. Koles. Welcome you all to this session. In this session, we will discuss some of the important questions from the Indian polity which has been asked by the Odisha Public Service Commissions in its civil service examinations in the year 2015 in its preliminary examinations. As we know, from 2019 onwards, the OPAC is conducting the Odisha Civil Service examinations in regular mode. As the year passes by, every year we may find 15 to 17 numbers of questions are being asked directly from the Indian polity, which constitute 1/6 of the total numbers of questions in the preliminary paper. So, understanding the huge importance of this segment, we will discuss the answer of some important questions as well as some other related informations. So before beginning the session, let me introduce first who am I. I am Dr. Kailash Chandra Devuri. I am a veterinary surgeon currently working in Fisheries and Animal Resources Development Department, Government of Odisha. So without any delay, let's get started. The first question was, who is associated with the introduction of the local self-government? As we know, we have three tiers of the government at grassroots level. The three tiers of the government, also known as third government. The first government is the central government, the second government is the state government, and at the grassroots it is known as local self-government. So at the grassroots level, we have the Gram Panchayat, the intermediate level, that is the Panchayat Samiti, and at the apex level, that is at the district level, we have the Jilla Parishad structure. So all these three structures, they constitute the local self-government. So the question is demanding who is associated with the introduction of the self-government. Obvious answer is the Lord Ripon. Lord Ripon is also known as the father of local self-government in India. He mandated to create a local self-government in the year 1882. For that reason, when the Government of the India Act 1919 passed, the local self-government was kept under the central government, and when the Government of the India Act 1935 was passed, it was kept under the provincial government. Right? So, to commemorate the when we got the constitutional sanctity, the constitutional recognition of the local self-government through 73rd Constitutional Amendment Act of 1992, we are celebrating 24th April of every year as Panchayat Raj Day. Please students, do not remember this 24th April of every year, we are celebrating it as Panchayat Raj Day to commemorate the day on which 73rd Constitutional Amendment Act 1992 was passed. Because on 1993 in this date, 24th April 1993, this 73rd Constitutional Amendment Act came into the force. So the obvious answer is the Lord Ripon. Another thing is associated information in the DPSP, Directive Principles of State Policy. There is an article 40 which is telling us to create or to strengthen the local self-government. Right? So this under Indian context, the local self-government is morely based upon the Gandhian Swaraj model. Here, what we have done, we have decentralized the power. Decentralization means from the center ru ame grassroots level ku ame power kiछि power delegate kule, so that at the grassroots level the panchayat से कौन करिवो निजर नीड अनुसार से प्लानिंग एग्जीक्यूट करि परिवो, प्लानिंग तयारी करि परिवो, ताको एग्जीक्यूट करि परिवो एंड सुपरविजन करि परिवो. सो देयर आर थ्री इंपोर्टेंट फंक्शंस: प्लानिंग मेकिंग, policy making, executions, and the supervision of this policy by the panchayats. Coming to the next question, the provision of providing identity cards to voters has been made. The correct answer is the Election Laws Amendment Act of 1975. under the Constitution of India, there is no any citations for the provision of the identity cards to the voters. The ROP Act itself, itself in the option, ROP Act two types, two ROP Act, ROP Act 1950 and 1950. But unfortunately, in the answer sheet we have 1958. But this doesn't say any sorts of any provisions. So obviously, the criminal in the election laws, this is also not the applicable. But it is quite tricky question. But the correct answer of this question is the Election Laws Amendment Act of 1975. Dear students, please do it remember. Coming to the third question, what will follow if a money bill is substantially amended by the Rajya Sabha? Very important. First, we have to know what is a money bill. Money bill is something that is associated with some financial matters, right? So money bill is a bill that has been enshrined in the Indian Constitution under the Article 1110. Please students, do it remember. Money bill is given in the Indian Constitution in the Article 110. Right? We have a parliamentary structure. Parliament means we have, under this parliament we have three important organs. One is Rajya Sabha, Lok Sabha, and another is President. So when money is the matter, it is associated with the people's money, nation's money. That's why when the nation's money or people's money is there, because the people are electing their representative only to Lok Sabha in direct mode. That's why the money matter is always linked to the Lok Sabha. That's why the money bill introduction can be done in the Lok Sabha only. Right? যেটা লোকসভা গোটে মনি বিল को आगत करबो से मनी बिलटा फास्ट प्रेसिडेंट कर रिकमेंडेशंस आछा दरकार प्रेसिडेंट को सर्टिफाई करबे प्रेसिडेंट ताको नॉट एक्जेक्टली सर्टिफाइड प्रेसिडेंट ताको अप्रूवल देबे कि प्लीज यू प्लेस इट इन द लोकसभा जब प्लेस होबो सेटा ताबरे लोकसभा जे प्रिजाइडिंग ऑफिसर स्पीकर से ताको सर्टिफाई करबे whether this bill is a money bill or not. After getting a certification from the speaker of the Lok Sabha, then this bill is discussed in the Lok Sabha. Then after the Lok Sabha, the bill is sent to the Rajya Sabha. Rajya Sabha कौन करवा? यहाँ पर discussions करवा. Any amendment, any suggestions, से invite करी पारे. Right? After this, से कुछ amendment की suggestions लगे से में भी लोकसभा को से बिल को रिटर्न कर दो. वेरी इंपोर्टेंट पेक्युलियरिटी ऑफ दिस थिंग्स कि लोकसभा राज्यसभा रो सजेशंस कि अमेंडमेंट को से मानि पारे कि मानि न पारे कि से कौन प्रकार एक्शंस नहीं न पारे. राइट? इन केस जब राज्यसभा रे से बिलटा कौन विदाउट एनी डिस्कशंस विदाउट एनी डिबेट विदाउट एनी अमेंडमेंट से हो पारानी देन राज्यसभा ताको 14 days रखी पारियो. जदि within that 14 days if the राज्यसभा is not taking any sorts of action on that bill or that money bill, the bill assumed to be passed by the Rajya Sabha, then that bill is sent to the president for his assent. Right? So here the president, he can withhold the bill or he can keep reserve his assent. But in that particular case, the president cannot send back the bill to the Lok Sabha, because prior the introductions in the Lok Sabha, the bill has to be approved. The bill has to be must get a consent from the president. Right? So all these things are related with the money bill. So the question is, what will follow? What will follow if a money bill is substantially amended by Rajya Sabha? The Lok Sabha may still proceed with the bill, accepting or not accepting the recommendation of the Rajya Sabha. No, this answer is obviously not. The Lok Sabha may still proceed with the bill, accepting or not accepting the recommendation of the Rajya Sabha. Okay, this is the correct answer, because we are not bothering about the functions of the Rajya Sabha, because Rajya Sabha has the power to keep the bill maximum for 14 days. The Lok Sabha cannot consider the bill further. No, the answer is obviously not. The Lok Sabha may send the bill to the Rajya Sabha for reconsideration. No, this is not happening. The President may call for a joint session. A very important thing for the money bill, there is no provision of the joint session. Joint session is called by the President under Article 108. Why the joint session is called? When there is a mismatch, or when there is a interest conflict between the Rajya Sabha and the Lok Sabha, or when there is when there is a deadlock, the President calls for a joint sitting. Right? So all these things you should do remember. Coming to the third question, Rajya Sabha dissolved after every very important questions. Rajya Sabha dissolved केते वर्ष रे मन रखिते स्टूडेंट्स इट्स नॉट सब्जेक्टेड टू डिजोल्यूशंस. राज्यसभा के डिजोल्यूशंस हुएनी. राज्यसभा इज ए परमानेंट चेंबर और परमानेंट बॉडी. फर्स्ट सेकंड, इन द राज्यसभा इन एवरी 2 years 1/3 of its member get retired. माने फर्स्ट 2 years रे 1/3, सेकंड 2/3 रे 1/3, थर्ड जदि टर्म रे 1/3 से रिटायर्ड हेबे. जो देखिया बुझबे आपन रिप्रेजेंटेशन ऑफ द पीपुल्स एक्ट जो अछि 1951 एतरे क्लियरली सेट कर द राज्यसभा हैज ए टेन्योर ऑफ 6 years. माने 6 year रे जते सब थरे एंट्री कले समस्ते पळेबे, किंतु राज्यसभा रे कोनोसी डिजोल्यूशन होबनी, राज्यसभा केबे भांगिबनी. वंस जदि गोटे मेंबर आपन राज्यसभा रो से रिटायर्ड हे जाउछंदी, देन देयर इज पेक्युलियर प्रोविजंस इन दिस ROP Act of Representation of the People's Act of 1951, because that member can be re-elected again to the seat of the Rajya Sabha. So the answer is it is not subjected to the dissolutions. Coming to the third questions, a money bill can be introduced only in, again we have discussed it, only in the Rajya Sabha, only in the Lok Sabha, because money is a public money, is a public asset, because the public is electing its representatives directly to the Lok Sabha. That's why the money bill can be introduced only in the Lok Sabha. So under the Article 110, जोटा money bill देइछि. Coming to the next question, Panchayat Raj is included in very important questions, dear student. So we have a federal structure. Some laws are there, some area are there on which central government can do legislations, on which only state government can do legislations or make laws about certain substances. Both central government and the state government both have the equal power to make laws. So under this federal structure we have three important lists. Another is the union list, on which the central government has the exclusive monopoly to make laws. Another is the state list, upon which the state legislative assembly can make laws. Another is a concurrent list. Right? The question is asking us the Panchayat Raj is included in the, it is always in the state list. Under the state list there is an entry level, entry 5. You may check it. Entry 5 of the constitution, entry 5 of the state list. You may find the provision of the local self government. Code Panchayat Raj lekha in local self government. Right? Another important questions, additional information I do want to provide. When in the time of the COVID pandemic, COVID is a health issue. It is a sanitation related issue. Right? So health sanitation is also a state list, which is under entry number 6, where the public health and sanitation is mentioned. Another questions আছে आपन फॉरेस्ट एजुकेशन सो को लिस्ट इसको सब कनकरेंट लिस्ट सो आसीबो. आपन क्रिमिनल लॉ, सिविल लॉ, मैरिज, डाइवोर्स इसको को लॉ रे सब कनकरेंट लिस्ट सो आसीबो. सो प्लीज स्टूडेंट्स डू इट, रिमेंबर. Coming to the next question, who among the following has the power to issue ordinances under the Article 129? It is not exactly 129. In the question itself, the question was wrong. It is 123 actually. Right? So what do you mean actually ordinance? Ordinance means, suppose लेट्स से आई एम गिविंग एन एग्जांपल सपोज बर्तमान गोटे पैंडेमिक चलती बर्तमान आम देश में कोविड पैंडेमिक आम देश में बर्तमान सपोज राज्यसभा आउ लोकसभा दुहे जो लेजिस्लेटिव बॉडी ये दुईटा बर्तमान सेसन में ना बर्तमान सेसन चलुनी बट गोटे अर्जेन्सी आसीगला कि आम देश पे गोटे स्ट्रिंजेंट लॉ तैयारी करने पड़ो बट this simultaneously but both houses are not in session when there is an urgency or when there is an exigency is there in our country or in our state, then at that time we must have to pass some laws. So at that time under article 123 the constitution is empowering the president of the India to make law on behalf of the parliament, or better to say Lok Sabha and the Rajya Sabha. So article 123 से यूज करिकी प्रेसिडेंट टेम्पोरारी लॉ से एटा बेटर से प्रोमोलगेट करिवे ऑर्डिनेंस को in order to meet the certain exigency or to certain undesirability, right? So similarly when a state is in emergency and both houses are not in session, the governor using its constitutional right under article 213 he can also make the ordinances, right? So here the president and the governor both are empowered by the constitution to make ordinances. As you know, the president and the governor both are executive, but they are making laws. But in our parliamentary structure, the executive, the legislative, and the judiciary is there. The main function of the executive is to execute or to implement the law. The function of the legislative is to make law, and the role of the judiciary is to check the law. So in this process, what is happening? The executive is, instead of implementing the law, it is making law. That's why ordinance is known as executive is performing the legislative work, right? But this is not exactly the same. When the executive is making law for the temporary law, it is violating the basic spirit of the constitutions. In the constitutions we have always a spirit, or we have any motto, that is executive is responsible to legislative. After the ordinance is promulgated either by the president or by the governor, it must be placed before either it may be Lok Sabha or Rajya Sabha, or it may be in state assembly or state Vidhan or state legislative councils within immediately, right? So after placing such ordinance, within 6 weeks that ordinance must be passed by the respective houses. If within the 6 weeks, if the Rajya Sabha or Lok Sabha or both, or in the state also, the state legislative assembly or state legislative council is not passing that ordinance, then at that time that ordinance seems to be seized. सेटा आउ लॉ रे एक्ट रे से कन्वर्ट हो पारिबो नाही. So I am giving another additional information here. There are important cases, 3 important judgment regarding to the discussions करबी. A case is there R.C. Copper versus Union of India. R.C. Copper versus Union of India in the year 1970. Supreme Court गोटे important judgment देले कि ordinance making power of the president can be challenged the way he is promulgating the ordinance at court, Supreme Court. So this is the famous judgment of the R.C. Copper versus Union of India. In second judgment, there is a case D.C. Wadha versus State of Bihar. Because due to this ordinance, the state of Bihar in the 1970 to 1990, 1985, a large numbers of ordinances are being promulgated by the then government. So in the D.C. Wadha versus state of Bihar, this in its important decisions, the Supreme Court told the legislative power of the executive must be exercised in exceptional cases, not in regular mode. In exceptional cases, when there is some urgency, when there is exigency, when there is any problem for the country or for the state, at that time the executive can make law on behalf of the legislative body. This is the famous important remarks given by our Honorable Supreme Court. In the third judgment, there is the very important judgment, Krishna Kumar Singh versus State of Bihar. The Supreme Court, in its landmark decision, what it told: issuing the ordinance is not an absolute entrustment, but is a conditional satisfaction that inconsistent exists regarding the necessity to take immediate actions. This similar case, this similar ideology upare koitile, like the DC Wada case, when there is an exigency, when there is emergency arises in the state, then that the president or the prime minister can make laws. So the three important judgment you have to remember: R.C. Cooper versus Union of India, D.C. Wada versus State of Bihar, and A. Krishna Kumar Singh versus State of Bihar. So all these things you need to remember. Coming to the next question, the doctrine of basic structure, very important. Please students, never forget this basic structure of the Indian constitutions has propounded by the Supreme Court of India in which of the following cases. So basic structure is always associated with the Kesavananda Bharati versus State of Kerala. Please students remember it. Right here. So basic structure, there is a separate class I will take regarding the basic structure. What आमे जानछन्ती गोटे आर्टिकल वो शॉर्ट रे कहि दोछि 368 अछि 368 आर्टिकल कहउछि पार्लियामेंट हैज द पावर टू अमेंड any provisions of the Indian constitutions, right? But article 13 कहउछि no, you cannot touch the fundamental right, you cannot violate, cannot abridge, cannot contravene the part 3 of the constitution, that is the fundamental right. So one article is saying you can abolish, you can smash any article of the constitution. Another article is saying no, you cannot touch the fundamental right, or better to say part 3 of the constitution. So when there is a tussle between the article 368 and the part 3 of the constitution, then in the landmark decisions, that is Kesavananda Bharati versus State of Kerala, the Supreme Court in its 13 constitutional bench was divided into 7 into 6, and in its landmark decisions, the Supreme Court has shown there are some important areas, some important spirit of the constitution that cannot be amended, that cannot be touched, that cannot be taken away by the parliament. For example, now you are enjoying the democracy, right? But the Modi government asile democracy enjoy. Modi government ko no, dear citizens, I am not actually in favor of the democracy. I am changing the constitution, making it the autocracy. Better to say, Ganatantra is changing to Rajatantra. No, you cannot change it, because election is a basic structure doctrine. You cannot touch it by using your unlimited power, that is article 368. So it is a famous important judgment that is given in the Kesavananda Bharati versus State of Kerala. Another case you should also remember, what is the Minerva Mill case and the SR Bommai judgment, very important. Under the Minerva Mill case, it is related to the property. Minerva Mill is owned by a private owner. When in the year 1970, Madam Indira Gandhi took the Minerva Mill into account and made it nationalized, citing the reason because there is mismanagement in that mill that is present in Bangalore. So that the owner of that mill, he challenged it in the Supreme Court. So in detail, you go through the Wikipedia or we go through the Google, you may get an more बहुत सारा information ଆପଣ ସେଥିରେ ପାଇପାରିବେ। Next, coming to the questions, writs can be issued for the enforcement of the fundamental rights when the fundamental rights is snatched away. But to say it is violated, it is abridged, it is contravened. Add that by important word, by the state. Then at that time a person can approach both High Court, both Supreme Court. Very important. A person can approach the Supreme Court using the article. No, a person can approach Supreme Court or High Court. So High Court gives an order. High Court or Supreme Court gives an order. That order is also known as writs. Supreme Court कहबे, dear citizens, I am issuing writs. High Court will कहबे, dear citizen, I am also issuing the writ. Right? So that writs are applicable against the state. Right? So the Supreme Court, using its constituent power, using its Article 32 and the High Court has the Article 2 to 6. Both have the capability or both have the power to issue writs against the state when the fundamental rights are in danger. So the question is saying the writs can be issued for the enforcement of the fundamental rights by both High Court and the Supreme Court. Please to remember, it is using Article 32 and High Court issues writs by using its Article 2 to 6. All these things. Besides this, you have to remember we have 5 types of writs. Then the High Court or Supreme Court issues. I am not going in detail. One is the habeas corpus, mandamus, certiorari, quo warranto, and prohibitions. All the details you go through the Lakshmikant book or any other matter that you have. Come to the next question. Which one of the following was the first state to establish the institution of the Lokayukta in the India? So, as we do, who is Lokayukta? Lokayukta is an anti-corruption authority. Better to say ombudsman, and is an ombudsman or anti-corruption authority whose chief aim is to investigate matter related to the corruptions, maladministrations provided to the citizens of this country, and to hear the grievances from the public regarding the corruptions and the maladministrations in the system. So, taking the spirit of this thing, the Administrative Reform Commissions in the year 1966, under the chairman of the late Morarji Desai sir, gave some recommendations to the central government to establish the Lokayukta in states. So, taking the very spirit of the recommendations, Maharashtra is the first state who had implemented the Lokayukta Act. In our country, we have a Lokpal and Lokayukta Act. Lokayukta at the state level, Lokpal is at the central level. So, Lokpal and the Lokayukta Act I am passed in the year 2013. It is also popular in the Lokpal Act. So, गोटे स्टेट रे किंतु लोकायुक्त द्वारा हमें एस्टाब्लिश करा होची से लोकायुक्त जो करा होची सेटा गोटे से लोकायुक्त जे कि गोटे जने जुडिशियरी स्ट्रीम रो मेंबर होइतो दरकार और तांकर अपॉइंटमेंट पाई से स्टेट रो चीफ मिनिस्टर प्लस आपनकर स्पीकर ऑफ द लेजिस्लेटिव असेंबली, लीडर ऑफ द ऑपोजिशंस और स्पीकर और द चेयरमैन ऑफ द लेजिस्लेटिव काउंसिल से एस्टाब्लिश थो ए माने सब मिसी की अपॉइंटमेंट ए माने सब रिकमेंडेशन देबे टू द गवर्नर देन अपॉइंट देबे लोकायुक्त को. सो दिस इज द होल प्रोसेस रिगार्डिंग द अपॉइंटमेंट ऑफ द लोकायुक्त. Coming to the next question, which one of the following was the first committee to demand constitutional recognitions for panchayat? Right? Purvara am desare panchayat thila, but we have no any constitutional recognition. The first step was given by the Balwant Rai Mehta committee in the year 1957. So I am एथरे देखली जते भी क्वेश्चंस पढुची आपनकर 2 to 3 numbers of questions are being asked from the panchayat raj institutions in the state in Indian context. So you must go through in detail regarding panchayats of our country. So the correct answer is the Balwant Rai Mehta committee, जे कि 3 tier government दे देइतिले, devolution of the power or decentralization of the power से फॉर रे देइतिले. Under 3 tier government we have at the grassroots, at the base level, that is panchayat, gram panchayat. At the intermediate level, that is block level, mandal level, we have panchayat samiti. Then at the apex level, means at the district level, we have the jilla parishad structure. All these things we have to remove. So 3 tier, likewise the Ashok Mehta committee during the Rajiv Gandhi era gave the concept of 2 tier committee. Then the Santhanam committee, very important committee, is there, who had given the recommendations for the creation of the chief vigilance commissions. And the GVK Rao committee is associated with the your PRIs structure. So here the important, so Balwant Rai Mehta committee, Ashok Rai Mehta committee, and the GVK Rao committee, the 3 important committees associated with the PRIs. But the Santhanam committee recommendations gave birth to the creations of the Central Vigilance Commissions, or better to say CVC structure. Coming to the next questions, in India, the collegium system was first introduced in relationship. So very often we are getting the news of the collegium system. So what do you mean by the collegium system? Collegium system is related to the judiciary. Generally, the senior occupies the top positions. This is the concept of the collegium system. I am not going in detail. You may make it Google. What is the first judge case? What is the second judge case? And what is the third judge case? How they get failed? Then there is an NJAC concept, National Judicial Appointment Committee. Then again it was failed. Then we have the collegium system. Collegium system is regarding the appointment of the judges or the appointment of the chief justice or any judges in the judiciary process. Another important things I want to, important information I want to share. Currently, Mr. Justice N.V. Ramana took the charge of the Chief Justice of the India position recently. So the full form of the NV is the Nathulapati Venkata Ramana, who is the 48th Chief Justice of the India. तांको पूर्व थे S.A. Bobde, जे recently retired. Right? So all these things are very much important. So collegium system is associated with the appointment of the judges in the judiciary structure. Coming to the next question, Central Vigilance Commission was set up on the recommendations of, as we have discussed already, CBC was on all the CBC was established on the recommendations of the Santhanam committee recommendations. Then what is the Gorwala committee report? You must be aware of the what is the Gorwala committee report. So Gorwala committee report is associated with the UPSC reform or Union Public Service Commission reform or the Civil Services reform. Then Kripalani committee report. Kripalani committee is Mr. Kripalani sir is a part of the drafting committee when our constitution was under prepared, right, in the Constituent Assembly. So Kripalani committee report. So another important thing. Next, coming to the question, which constitutional amendment provided for the setting up of the administrative tribunals in India? So administrative tribunals by हमको 42nd Constitutional Amendment Act was directed to create a administrative tribunal in India. The 42nd Constitutional Amendment Act was passed in the 1976 when our country was under internal emergency during the Madam Indira Gandhi period, right? Then at the time administrative tribunal has been made. So we have an act, that is Administrative Tribunal Act of 1985. We have inserted, using this article 42 of the Constitutional Amendment Act, 323A and 323B. So this 323A is related to the administrative tribunal and 323B is related to the tribunals of other matters. Other matters means land, labor, your taxations. This matter पे other tribunals established ହେଇଥିଲା. Right? So we have three different types of tribunals. Another central administrative tribunals, and the state administrative tribunals. Another thing is the joint administrative tribunals. So see, administrative tribunal main function है आपनकर recruitment and condition of the services. जो थे आप रिक्रूटमेंट होते आप कंडीशंस ऑफ सर्विस यदि किछि इन not in the sense of the your service code book, then you may approach the administrative tribunals against the recruiting authority. Right? So you have to remember all these things. Then coming to the next question, which of the following committee voiced concern about the criminalization of the politics and politicization of the criminals? Very important. The correct answer is the Bhora Committee report. Very important. Election reform measures. Bhora Committee has been entrusted to give its report on the criminalization of the politics. Then the other options are there. The Tarakonde Committee, right? Tarakonde Committee was in favor of the making the voting age or reducing the voting age to 18. This is the major recommendations given by Tarakonde Committee. Then in the Sachar Committee is telling about the socio-economic and the educational status of the Muslims in our country. Besides this, it also had given recommendations regarding the inclusions of Muslim minorities in the IS and the IPS. This is all the things are related to the Sachar Committee's recommendations. Then another is the Indrajit Gupta Committee, who is associated with the funding to party during elections. So किए पैसा देला किए पैसा न देला गोटे इलेक्शन पार्टी इलेक्शन कंडक्ट करा सेटा ता ऊपर कौन प्रकार रिकमेंडेशंस नथिला. Recently we have the electoral bond concept, right? So if people please go through what is the electoral bond concept. Basically Indrajit Gupta Committee is associated with or election state funding to the elections, right? Coming to the next question. Okay, already we have covered everything. So from the important chapter we have already covered. So if you have any doubts, then please give your valuable suggestions in my comment box or any clarifications, better clarifications in my comment box. So thanks for watching this lecture till the end. So my next session will be on the Indian polity questions that has been asked by the OPSC in its 2016 prelims paper. So until that next video, please subscribe Dr. Kole's channel's lectures and place and subscribe this button. If you have truly enjoyed this video till the end, please subscribe it, press the bell icon and stay in touch. So until the next video, stay safe, stay indoor, have a good day. Thank you. God bless.